Now, we do have a bunch of questions, so Alessia, maybe we can have Mirta address some of these questions on the visas, and then Patrick, if there's any questions on the investment, you can address those.
Sure.
So our first question is, with the e-visa, would the visa holder and his or her spouse be able to work at the E1 visa? I'm assuming also the E2. Would the visa holder and his or her spouse be able to work at another company in the US in addition to the company that the individual is investing in for the E1 or E2 visa? So with the e-visa, the principal investor may only manage and direct that company. So the spouse can work anywhere, but the initial investor is tied to that company, which is why I often suggest when a client does an e-investment that they invest in essentially create an entity that is a holding company, and that holding company be where the initial capital is invested, that be the E company that you apply the visa for, but that company holds your shares or interest in whatever the operational business is that has a separate FEIN. That way, when you apply for the E2, if you can describe in the application that this is your initial investment in this operation, but you plan to expand and you list those other areas in which you might, maybe you want to open more franchises of the same or different or products, or maybe you want to do other services or businesses. If you create an initial holding company that has a diverse portfolio, the first operating business underneath the umbrella will allow you to expand into other areas without having to necessarily amend the E2. You do have to work with your attorney to make sure that each additional investment under the umbrella meets the original petition descriptions, but that's one way that you can allow yourself to have a more expansive employment as the initial investor. Another thing to do is to consider that your E2 company, if it's a services company, can provide your services as a subcontractor to other businesses. But you may not be a direct employee of another company if you have applied for your E1, E2 as an investor, or if you have been sponsored by an E1 or E2 company as a manager or specialized knowledge worker. Why don't we talk about, does the EB-2 require a sponsorship from a US company, Mirta?
Well, it depends what category of EB-2 we're referring to. If it's the EB-2 National Interest Waiver, we don't need sponsorship from a US company. Basically, the National Interest Waiver EB-2 category allows the foreign national to self-petition, meaning that they don't require a job offer from a US company. However, if it's the EB-2 labor certification process, you do need a sponsoring company. So it depends on what kind of EB-2. So we have the two options, the self-petition or the labor certification, which does require you a job offer from a US company. I think we also have a question for you, Michelle. Can you do adjustment of status from F1 to an EB-2 with national interest waiver?
So you can do an adjustment of status from an F1, actually from any non-immigrant visa to an immigrant visa in the United States. So it can be a family-based petition, it can be any of the EBs. And so long as you have a valid I-94, you can legally file for adjustment. Now, you also have to be compliant with that I-94. So having if you're on an F1, you get this I-94 that's called duration of status. Once you stop studying, you can continue to be in the United States without accruing unlawful presence because you still have an I-94 that's open-ended. It's the duration of status. But you won't be able to adjust if you don't show that not only do you have the valid I-94, but you're complying with the conditions of that status. There's a few exceptions, but generally you need to have a valid I-94 and you need to be compliant with the status to adjust. With F1s and all the other non-immigrant visas except H-1B and L-1, there is a non-immigrant intent. That means when you apply for any visa except for H-1B or L, you have to demonstrate that your intent is not to remain in the US and that you plan to go back to your home country. Now, that doesn't mean that you can't ever want to get a green card in the future, but it does mean that once you have an intent, defined intent, and taken steps towards acquiring a green card, such as starting a labor certification, or you want to file your I-140. If your decision is to adjust, then you should not travel on the non-immigrant visa within 90 days of filing the I-140 or adjustment. So we always tell the client, once you've made a decision that you're here on a non-immigrant visa and you want to stay and pursue a green card process, you can no longer travel. We have to wait 90 days at least from your last entry before we can file an immigrant visa petition and adjustment. And you will not be able to leave until the travel document on the adjustment is issued. Now, the reason that we do not discuss adjustment processes for people that are on a tourist visa or ESTA outside the United States is because we cannot advise a client to pursue an immigration strategy that is going to force them to make a misrepresentation at the entry to the US, right? So if you're coming for tourism, but you've got an attorney that's doing an EB-2 for you and your plan is to adjust after you enter on that tourist visa, you're committing fraud on entry by telling that officer you're coming for tourism. So we don't offer that option to clients, adjustment option to clients that are outside the US on tourist or ESTA visas, or for clients that want to continue to travel during their immigrant visa process. For those individuals, we tell them you're free to come in and out of the US, but you can't adjust. You have to do the process consular. And as we know, consular processing is now taking substantially more time than it used to. So it's been a bit of a problem.
Thank you for that. We also have a question in their premium processing for EB-2 National Interest Waivers. Yes, there is premium processing. However, it's limited for the moment, where USCIS is only allowing premium processing requests for cases that were filed with USCIS before June 2021. We expect that hopefully that premium processing exception is extended to other cases, but for now, I don't know, Michelle, if you have any other information, but for now, only cases that were filed with USCIS before June 2021 will be able to request an upgrade to premium processing.
You know, I think what they're trying to avoid is people coming into the United States on a tourist visa and applying premium processing within the validity of their visa so that they can get an approval and adjust. So they don't want the EB-2 National Interest Waiver to be used as a way to circumvent the 1-year processing time of the Department of Labor. So I think we're going to continue to see premium processing being offered only after 1 year, because it's similar to the EB-1. The EB-1, you have to have your company operational for 1 year before you can apply.
Right.
So the labor certification process requires a year before you can get to the point where you can apply the I-140. So I think they're sort of taking that same logic, that they don't want to create a visa category that shortcuts the timelines that all the other immigrant visas have. And I'll go to the next question, which I think is a good question. And that question is there a max amount of EB-2 or NIWs issued per year? So unfortunately, our government does not authorize more than 140,000 green cards being issued per year in the EB categories. We have had a few more in the last 2 years because family-based visas, family can use 250,000 a year. That aren't used abroad, those numbers the next year roll into employment-based. So we had more than 140,000 available this year and last year because the consulates were closed and family-based visas weren't being issued. The problem is that each category has its own number. So EB-1, EB-2, and EB-3 each get 40,000. EB-4 gets 10 and EB-5 gets 10. So that's how we get the 140,000 total. Those numbers include family members. So a family of 4 will take 4 numbers. So it's not petition based, it's number of families in the group that get issued each year, either as a green card approval through adjustment in the US or at the consulate. It's because of the limited number that years ago, I guess, Congress enacted a rule that said that every country was going to have equal access to green cards, and they put these caps on how many green cards a particular country could use. The idea was that they didn't want to promote immigration from primarily one country. And prior to the 60s, when these caps were enacted, the laws were structured to give preference to European and Caucasian nations. So the idea was to create better diversity, that we were going to give all nations equal opportunity and access, and not let any one nation take more than 7% of the annual green cards in either family or employment categories. Unfortunately, this has created tremendous waiting lists for certain nationalities, primarily Indian and Chinese nationals in the employment categories, and in the family-based categories for Mexican nationals and certain Central American nationalities that use those green cards applications more. There has been different legislation proposals to either increase the number of green cards so that the waiting lists for certain nationalities aren't so long. There's more troublesome legislation currently in the House that would eliminate the caps entirely and force the green cards to go to the people that are already in the waiting list before any new applicants can get them. I'm firmly opposed to that because it does mean that anybody in the employment-based category, anybody from India will not be able to get a green card that doesn't already have an H-1B and isn't already here with that petition pending and approved. No new applicants will be able to get that green card for probably 8 to 9 years because the backlog is so big. But for right now, there isn't a limit specifically for NIWs. It's just 40,000 a year for EB-2s with labor certification or national interest waiver. There has been some talk about exempting national interest waivers and EB-1s completely from the cap. Unfortunately, politics, there hasn't been a consensus in Congress to advance that kind of legislation. So can one travel outside the US and return while under the conditional green card for the EB-5? If you have your conditional green card approved or you have your I-551 stamp, you can travel during the validity of that document. And if you file for renewal at the removal of conditions period, you can get temporary I-551 stamp upon filing the I-829, which will allow you to continue traveling while you wait for the removal of conditions to be approved. How long does it take on average to get the EB-3 visa? So the EB-3 is always with the labor cert. So the first part with the Department of Labor can take a year to 18 months. Now that's our firm's numbers. We do implement certain strategies. That means we're able to process these cases faster than most attorneys because a lot of attorneys wait for the prevailing wage to get approved before they do the recruitment, and they will take months to define the strategy before they submit the prevailing wage request. So I know that there's attorneys that take 2 to 3 years just to get the labor cert approved. Our standard is 1 year, 18 months with audit. Once the labor cert is approved, the I-140 can be premium processed. We usually put those cases together in 30 to 60 days, filed at premium process, so no more than 90 days to get that approval. And then the green card part depends on whether you're doing it consular or as an adjustment of status. As an adjustment of status, we're seeing 8 to 30 month processing times, depending on what service center and what local office is. Most of these cases have now been getting approved in the last 2 years without interview. Some get interview. Consular, right now, we are seeing appointment scheduling for cases that have been documentarily ready with NBC for over a year. So I'm telling clients it's about a 2-year wait from the I-140 approval to get to the green card interview. But again, that could take longer. And then this last question for you, Mirta, as an F1, are you compliant to adjust only while studying or also during OPT and STEM extension?
Yes, so you are able to explore an adjustment of status if you're also during your OPT year or your STEM OPT years of employment, as long as you have maintained your employment in the United States and you don't have, and you haven't violated that status.
And I'd also like to point out that for TPS holders, there's been quite a bit of back and forth on how that works. TPS is now it's considered status. The Supreme Court has recognized it as status. So you can adjust status from TPS, but it requires, since adjustment of status requires that you show you have maintained continuous lawful status since entry. For TPS holders that were prior to getting the TPS, maybe had an asylum pending or other issues, they need to get the TPS parole, leave, and be readmitted under the new policy before they can adjust. But I do not recommend anybody going ahead and taking those steps until they've properly spoken to a well-informed attorney that has experience, dealing with asylum applications, TPS adjustment, and these business immigration issues. It's the TPS parole, departure, and reentry will benefit employment-based category applicants immediate relative family-based applicants, but it doesn't work for the preference categories. So LPR spouse, adult children of residents and U.S. citizens, and brothers and sisters of U.S. citizens. Those categories will not be able to cure by doing the TPS parole. So talk to your attorneys about that, but that's another option that's opened up in recent months.
Perfect. I think we also have, how can we contact Michelle for a consultation?
So you can call our office at 305-579-9218. And you can also email me directly or Mirta. My email is michelle@canerolammers.com. Mirta's is mirta@canerolammers.com. And we put up the contact information for both our firm and Visa Franchise. Honestly, if you're investors, you're thinking about investment in the U.S., tell your friends about Visa Franchise and their partner website, Vetted Biz. It's a tremendous resource. And we've been working with Patrick for years now, and he has never let our clients down in his professionalism and objectivity. So I really, with so many predatory practices on immigrants, I really want to push people to seek out reliable counsel on these decisions, because at least our clients, a lot of them being Venezuela, are fleeing countries with everything they have. To come here and risk losing that is not something we're looking to do. We want to make sure we're helping our clients get stable footing in the U.S. so that they can succeed both in their immigration status and the business decisions they make. So thank you, Patrick, for being with us, Alessia for organizing, Mirta for being my partner and an excellent attorney, and all of you that listened in today for supporting us and participating. Hopefully it was informative.
No, thank
Thanks
you
so much. We appreciate it.